Stars. Today is December 1st, and I hope you all had a wonderful Thanksgiving break and a lot of interesting news since that time. We've got travel bans and then, of course, the House bill. So I'm going to give everybody a few minutes to start joining us, and then we will get started with the latest information. And so interesting changes on the horizon. You know, the new travel bans and COVID precautions. The last words from Charlie Oppenheim, immigration proposals were included in the House bill. So let's first talk about the travel bans. We know that there's a new variant out, and this will be a common occurrence going forward until we can globally get a handle on this, you know, the virus. So it's the new one is to combat the Omicron variant. So on Monday, a new travel ban went into effect, suspending entry for immigrants and non-immigrants who were physically present in the 8 African countries where the Omicron variant has been detected. Individuals present within the 14-day period preceding their entry or attempted entry will not be allowed to enter. The new variant has multiple mutations and is considered a variant of concern by the WHO. There's an increase of reinfection. The ban does not apply to U.S. citizens, permanent residents, nationals, spouses of U.S. citizens or permanent residents, parents or legal guardians of minor U.S. citizens or permanent residents, and there's some additional exceptions. The U.S. officials are considering new restrictions and may require all travelers to be tested for COVID-19 the day before the flight and tested again on returning home, regardless of the vaccination status. It would apply to U.S. citizens and permanent residents as well. The U.S. Travel Agency met with the White House and stated that they are not expecting additional travel bans or travel restrictions at this time. Pandemic conditions can change, so countries could implement their own travel precautions. So always evaluate your travel plans carefully. The last words from Charlie Oppenheim. Remember, he is retiring. So he has been in discussions with his potential successor about flagging potential retrogression at least 1 to 2 months in advance. Repeated that it is important for applicants to timely submit visa applications and submit all documents. Commenting on the USCIS and DOS processing, USCIS was processing at the rate, remember we reported last time, 7,000 to 8,000 per week in August and September, which probably won't continue, but is a pretty strong showing, especially when we discuss the trends for the past couple of years. DOS used more numbers in October than expected, lower refusal rates, missing interviews, and applicants are more attentive by providing all the documents. Lots of overseas EB demand, and we may get close to approaching the annual limit. Impact on Eb2 India is a concern because of potential upgrades. Fewer otherwise unused Eb2 numbers could fall to India Eb2. China and India are current for direct Eb5 investments. No reauthorization language in the continuing resolution so far. An estimated 19,880 Eb5 visas are available for the fiscal year, a record high, beating out 11,000. Without China Regional Center numbers, Oppenheim made direct investments current and may need to impose final action date next summer. Eb2 advanced 6 months, greater than originally thought, but they decided to test the demand and will push back on advancement going forward, and may aggressively once again before April 2022. Movement in January 2022 will be indicative of what we should expect over the next few months. Watch Eb3. DOS is processing lots of the rest of the world EB3s abroad. potential for increased processing in Manila, Mumbai, Guangzhou to address the backlogs of following to join applicants could impact the final action dates for China and India in the second half of 2022. Family preference categories continue to be utilized and final action dates may be necessary in the next months for F2A spouses and children of permanent residents. House passed a social spending bill that included extensive immigration reform. The provision for the visa recapture, preventing a loss of 222,000 unused family-based visas and 157,000 employment-based visas that expired last fiscal year. They would expand processing capacity by adding $2.8 billion to the USCIS, would allow those few undocumented categories to be present in the US up to 10 years for work authorization by offering parole, which is not an immigration status, it's an authorized stay. And we had a webinar just distinguishing the difference. It would benefit some 6.5 million people, and 3 million of which would become eligible to apply for permanent residency because they are immediate relatives of an adult US citizens. It has yet to be presented to the Senate parliamentarian, who advised against including other proposals stating they would be beyond the budgetary impact and represented substantial change in policy. Like they can't, at first they were hoping to offer a path for citizenship. So this is not that, but it is at least some form of relief so that in two separate bags. One is, you know, for those here who are undocumented, the dreamers, the TPS and so forth. And then the other major benefit is, you know, the ability to avail the unused visa numbers. I know it would have been nice if it all went to employment-based, but it's still better than nothing. Then there are some provisions for the ability to file an adjustment under certain categories if you pay a fee earlier than usual. So, and there's some adjustment with how visas are being allocated. So we will see how this package goes. I know a lot of people are already sending letters to the their senator's office. Kara is working on one right now, so she will post it on the Telegram groups. Although you are not eligible to vote, I'm sure all of you have friends who in your area that are US citizens. Have those citizens send out the letter to your local senator, and that way you can be a part of the change you seek. So that is it for our immigration updates. Let us go ahead and get started with questions if our moderator is ready. Hello, Shaker.
Hello, Lakshmi. Hello, everybody. Good afternoon. Glad to see you all after a couple of weeks. I was not here traveling on your behalf, everybody's behalf. But, all right, so we will pick some questions. There are some questions from YouTube. So I'll just go chronologically. First question is from Ram K. Hi, Lakshmi and Shekhar Garu. My 485 was filed by my future employer, not my current employer. Got EAD. Can I stay as unemployed, leaving my current employer for a few months now in US? Will join my future employer once I get my GC. Thanks.
Well, you know, here's the thing. There are two issues, right? One is because you're both on a status of an adjustee, and I would imagine you're on an H-1B or L. So as an adjustee, yes, you can. But remember, I don't know if your I-140 has been approved or not, but you don't have a safety net. So if you don't work, if you leave your employer and remain unemployed for a few months, you would have violated your H-1B status. So your safety net, that means if something should happen to the adjustment, because it's not approved yet, right? And sometimes there are denials that have nothing to do with the petition, maybe a mistake by the USCIS. So I always like people to maintain a separate status in addition to the adjustee status.
All right. Next question is from an anonymous AA. Hello, I recently joined an organization leveraging AC21 on GCEAD 2 months back and haven't filed 485J with new employer yet. I have now better offer and trying to move to a new employer. So want to know if I still need to file 485J with my current employer or need to file only when date is current.
Well, I want to know if you downgraded at all. I mean, was it just a mere AC21 change, or was it sometimes people change and downgrade? As long as there was no new I-140 attached to this current AC21, I would just go ahead and submit the 485J for this and then submit it for the other. Because if you do get an interview and they look at your returns and your payroll, they will see that you changed. So at least that way you can show that you complied.
If you are still around listening, Mr. or Mrs., you can put your response in the chat so I can relay it. But while we are waiting for yours, I'll take the next question. Ritesh Kumar is asking, my wife is on H4 and is traveling next week to India. We received the EAD AP combo card. She will return back on AP. She will carry a copy of her US citizen birth certificate along with I-485 receipts. Let me know if all good with this. Thanks.
When you say she'll carry the birth certificates,
She'll carry a copy of our US citizen birth certificate along with I-485 receipts.
It can't be your US citizen birth certificate if you're an I-485. It must be your children's US citizen birth certificate.
It says our US citizen birth certificate must be his kids.
Mm-hmm.
His wife is traveling on H4. Is traveling. So Ritesh Kumar is saying, yeah, it's kids.
Yeah. So no, that shouldn't be a problem.
Shouldn't be a problem. So the AA before sent a response. Yeah, mine was straight EB3 filing, no downgrade for the 485J question.
Okay, so then, I'd submit a 485J with this employer, and then when you port, I would submit another 485J.
All right, got questions from YouTube. JJ Investor. Will COVID-related country ban help immigration for 2022 as well?
We don't know that. Thank you, first of all your YouTube folks for joining in. Thank you for our attendees that are here for the new time on Zoom and those who are newly joining us. I appreciate your support. It's hard to predict. I mean, I think we're going to be seeing until we can get a control of this, get more people vaccinated. One thing about this strain is it just keeps mutating. And, of course, as time goes by, we're going to become more, our immunity is also going to build. But it's hard to predict. But if, we see a couple of more mutations, especially in those countries where you see a lot of immigration to the United States, that may impact the numbers a little bit, but we'll have to wait and see.
All right, next question also from YouTube. Ravi Shrao is asking, hi Lakshmi and Shekhar, changing my status from H1B to my I-485 EAD. Can I work only as part-time using my 485 EAD until I get only after getting my GC plan to work full-time? Thanks.
Well, remember, as I said earlier, there's two issues when you are in an H1B and you're an adjustee. Now, you can always file an H1B for part-time employment. But if you use your EAD to work for somebody other than your H1B employer, you will no longer be in valid H1B status. And I always think that it would be a good thing to maintain both. And you can work part-time on an H1B if the organization is willing to sponsor that.
Okay. Next question from the Q&A box, Gopal Arthanari. Hi, my priority date is current in both Eb2 and Eb3. Filed a 485 using Eb3 downgrade, new, on October 2020. Eb3, I-140 approved. I think my 485 is stuck at Texas Center. Would refile on Eb2 or interfile help to get my GC approved?
Yeah, you can always interfile. I would do that, especially since you filed on Eb3 and giving the advancement of Eb2. It never hurts. What you're just saying to the USCIS is, I've got 2 approvals, so approve me in whatever capacity that works. Texas is one of the slowest centers, and the USCIS, DHS, and the USCIS recognize that they have astronomical backlogs. So they are hopefully, with this money infused into the USCIS, one of the things that they really want to do is eliminate these backlogs.
All right. Next question is from YouTube. JJ Investor is back. And they're asking, my wife got her birth certificate on 2013. Since her birth certificate was submitted to school, does she need an affidavit while filing 485?
I always suggest that if your birth certificate was not issued close to the time that you were born, then when you submit that birth certificate for purposes of immigration, that you include affidavits. If she's got a, what's that card? Aadhaar card, or 10th standard leaving certificate, all those things you should submit in addition to the birth certificate.
Next question from YouTube, Sweet Seller. That's the name. Would Eb2 retrogress due to refiling and interfiling in fiscal year 2022?
Don't know. I mean, as far as the advancement, we're not going to see the 6-month jump like we did recently. But, and then you don't know what's going to happen with the legislation. There is no harm in interfiling. It doesn't hurt you because you still get the Eb3. You're just saying, additionally, I've got the Eb2. Why not hedge your bets?
All right, and I'm saying his, but Sweet Sellers, another question. When refiling is submitted, could it be processed independent of previous AOS, or do they have to do the matchup with previous AOS before approving?
Well, they will do the matchup. What you do is you put your I-485 receipt number when you interfile on the envelope and the cover letter. And you say you would like this to be joined with that filing. Because your adjustment has already been in the process for some time. If you refile again anew, and you can, you're going to be in the back of the queue, right? Why not take advantage of that adjustment that has been in the queue for some time?
All right. JJ Investor is back. I think he just wanted a clarification when you suggested about interfiling. He said, will interfiling or refiling for Eb2 help Eb3 advance in second quarter?
They're also saying, because remember, it's not just one factor, there are many factors. And one of the things that we did learn is that Eb3 for the rest of the world is processing at an astronomical rate. So we'll just have to wait and see.
All right, back to the Q&A box. Gopal Arthanari is back. He's asking, is there anything we could do to get pending AP approved? It's been pending since October 2020, raised SRs, but no use.
Well, if you look at, there's many ways to contact the USCIS. Service request is one of them. Emma is another, but we will put a link to our YouTube video that talks about the many ways in which you can contact the USCIS. So I would just keep doing that until you can get a response. Sometimes nudging them a little bit helps.
Next question from the Q&A box. Ritesh Kumar is back asking, my wife is currently working on her H4 EAD. Will it be okay and safe to use if my H4 spouse uses her 485 EAD after expiry of her current H4 EAD? I was the principal applicant, will continue to work on H1B status and will file H4 extension.
Absolutely. H4s don't have the restrictions that the primary H1B does. So she can work on her H4 EAD, she can work on her adjustment EAD, it doesn't make a difference.
He's got a follow-up question. He says, if my wife enters US on an AP, in bracket, got because of Eb3 downgrade, she will be on parole status. Can she continue to work on H4 EAD, or she has to use her I-485 EAD AP to continue working with the same employer?
Remember, the restriction only applies to the H1B visa holder. It doesn't apply to the H4. So it doesn't matter.
So in the chat, team has put some links navigating the USCIS contact center. So you can check those out, the YouTube seminars that we did. The next question from YouTube, Sweet Seller is back. How does CSP play out when date becomes current on FAD from filing dates? Will USCIS send any notification that the child's age would be frozen?
Well, they will do the analysis, and we have a YouTube video on how that's calculated, and they'll put that in the link. So take a look at that, and if that is helpful, otherwise, if you have any additional questions, email us at info@cellolaw.com.
Thank you, Ritesh, for your comment. That's all I have right now, but while you're waiting, I just wanted to, if you can, give a little update on the EB5, and I just wanted to tell viewers that, I was away because I visited the project site, the Western Center last week. I had a couple of investors from India. I took them and we spent the whole day along with our good friend, Daniel Robinson. So, and some things are developing day after tomorrow, I believe. So Lakshmi can give a little bit of overview on what's happening now and what can happen. So
right. So the only provision within the House bill related to EB5 is just the ability, if you are otherwise eligible and there's a queue, your visa number is not available, to pay an additional fee if you meet certain criteria and adjust. Well, that really doesn't apply, right, because EB5 is current even for China, but for direct investment. So that's one thing. Number two, there is talks of reauthorization, and the Congress has to pass the omnibus bill, which is by the 3rd. So there could be something that's attached to that. I haven't heard anything yet that it will, but if they do attach a reauthorization to that, most likely than not, the threshold amounts will be increased. Yeah.
Just wanted to update the viewers, that we had visitors from Bangalore, Hyderabad, so a lot of traction. EB5 is getting a lot of traction, especially because the investment is at 500. And although the regional center program is not renewed yet, the projects that are currently on with the regional center, they have changed some of their articles, and they have made adjustments in such a way that you can participate, invest as a direct EB5 investor. So that's why all these folks have come, and we are filing, their applications today, tomorrow. So it's a busy time here. But I just wanted to let you know. So just in case if any of you are interested, just shoot an email to us, info@chalalaw.com, and I'll be the one reaching you out. Give me your best number to call and the best time to call you. I'll update you.
And for those of you who have been joining our weekly webinar, especially those on YouTube, please, we've got links below that can get you registered for our webinar so you know when they'll be happening and what we'll be talking about. Our YouTube videos are chock full of information. So if you subscribe, then you will be able to find out when we upload a new YouTube video. And please, if you like our content, share this with your friends. We're on Facebook, Twitter, Instagram, and then we have our own immigration Telegram group. It's a community where people are just so helpful in probably similar situations as you. And the nice thing is, this is one of the few forums that I know of where an immigration law firm is, providing information to that group without charging any fee.
All right, got a couple of questions coming. Ritesh Kumar from Q&A box. My priority date is September 2014 with both Eb2 and 3, I-140 approved. Do you anticipate that my PD will get current in the next 1 or 2 years in final action chart? I just sent the interfile medical I-693 to USCIS.
It's hard to predict. There are too many, like I said, we had a YouTube video where we talked about what are all the factors that impact the visa bulletin. And those things are dynamic factors. So with those factors constantly changing, issues of COVID, we don't know how many people have filed for, since EB2 has gotten better, interfiled for EB2. So there's a lot of factors in play that impact the visa bulletin. I wish I could predict when your priority date would be current, but unfortunately I cannot. I think we will definitely see slower movement without congressional action in 2022.
All right, some couple of questions from YouTube. The follow-up question from Sweet Seller. My question is not about the CSP calculation. Wanted to know how would we be notified that the age is frozen?
You're not going to be notified that the age is frozen. There's no notification process. That's why I sent you the calculation. You've got to do the calculation yourself. And then USCIS, yes, USCIS will do the calculation, but you've got to do the calculation to make sure that they've done the calculation correctly. So during the period that eligible petition is pending, the age of the child is frozen. So let's say it was pending for 1 year. And at the time the petition was filed, the child was 16. So once the petition is approved, the freeze is over. So the 1 year is added back, they're 15, but they have to, the visa number has to be available within the 1 year period before they turn 21, according to their CSPA age.
All right, there's a link in the chat, how to calculate the CSPA. So Sweet Seller, please, help yourself. If you have any questions, send us an email.
And guys, you have to be you have to take a really active role in your immigration process. This is something that, you've got to be the one to know what your priority dates are, make sure that they're being applied correctly, make sure the CSPA date is right. So if USCIS gets it wrong, you'll be able to correct them. So that's why I was like, just make sure you calculate it so you can be the captain on your own immigration journey.
Yeah, we have a great story to tell you, but that's for another day. But definitely, keep on top of your immigration dates and filings, and put some, calendar events, recurring events, reminders, whatever it takes. The next question from YouTube, Soham is asking, I have a question. My current employer applied GC via Eb3 perm and my PD is 2012 May. Thus, I am unable to file 485. They've started new PWD for Eb2, which will take another 1.5 years to apply for 485. I have another option to go back to my prior employer who filed Eb2, but he has negative balance sheet, kind of shady. Is it advisable to go back to him or wait for Eb2 new filing for next 1.5 years?
Yeah, that's a good question. I mean, remember, every time you file an I-140, you have to, well, you said your old employer had already filed the I-140. So all you have to do is file the 485 with that I-140. So you could do that. And then because you're not filing a downgrade or filing a new I-140, the ability to pay issue may not come up. Is there a risk that there'll be a question at the 45 stage? Usually they don't, but there's always that, you don't know between now and then how adjudications could change. But as long as why don't you try to do both? Why don't you leverage that with the idea that you'll go back to him after it's approved and make sure you document that. You must have the present intent to work for the employer that is sponsoring your I-485. So I would do that. And then because the I-140 is already approved, you don't have to submit ability to pay documentation with the I-485. And concurrently have your new employer file for the Eb2.
I just laughed, grinned, because it's been a while since I heard the term shady. I used to use that a lot back home. Well, there's a link there in the chat, ways employers can demonstrate ability to pay. So check that out. Next question from the box, AA. Biometrics given in September 3rd week, and since then, no updates. What can I expect? When can I expect the card to be mailed?
There's no set time, unfortunately. It seems like they're varying across the board. I would just, September, I would just, when you're 3 months out, I would nudge them. So use that link that we have in the chat that tells you how to contact USCIS. And as I said, be the one that's steering your immigration ship. So you call them and say, how come I haven't gotten it yet? Or when can I expect it?
That's about all I see on the, I think there's just one came just now from the, from YouTube, Ms. Sweet Sweller. In terms of processing time, how does a second AOS with Eb2 and Eb3 compare against a single AOS, just Eb2 or Eb3? Just about the same, or second AOS takes away more time?
Yes, because remember, when you file, even though your priority date is not current, the USCIS is doing a preliminary review of your adjustment, right? So it's already moved along a little bit. If you file, they will look at it anew. So clearly, if they've already done a preliminary review, it seems to me that it would be better to interfile is not going to delay your adjustment process. It would just allow you to benefit if from two categories, either the Eb2 or Eb3. But if you file anew, it has to go through that review process all over again.
Yeah, so here's today we have to make an exception and take the last question. And if you have questions, please send an email to info@chalalar.com. And if we didn't answer your question, I apologize. I must have missed it. But here's the last question from Ritesh Kumar. My friend's employer changed his address today. Do filing H-1B extension with the employer invite RFE as they just have new lease agreement? do we need anything else to establish the address change from employees' part?
No, I mean, if they've got a new address, see, the main issue with H-1Bs is sufficiency of work. So the new address will not impact anything as long as they've got, it's a valid lease. And if the employee is working there, they sometimes will look at square footage, right? So, and that it's an actual office, not a virtual office. So that's the only thing to look out for. Otherwise, that's not a problem.
Well, that's about all. I just want to one last plug in about the EB5. If you're interested, please, send an email to us, and with the best number and time to call you. I'd be glad to, talk to you guys.
And join us again next week. Well, we will be hopefully having some positive news about what the Senate's doing about the spending bill. And then I'm not sure if it's next week or the week after that we were going to be speaking to about processing in Mexico, which may be a good option for a lot of people. So, chat with us. If you are on our Telegram group already, tell us what kind of topics you'd like us to cover. We would be happy to do that. And until next week, I hope you all stay safe and have a great time. And thank you again for joining us today. I want to thank my team again for putting this together. Special shout out to Kara and Shaker for moderating. But it's like I said, we are the face of this webinar, but there are a lot of people that put a lot of work into this.
Yeah, just wanted to say it is December 1st, so it's holiday season time. So be careful, stay alert when you're shopping. Make sure you lock your cars. Don't leave anything on the front seat that people can see. All the cybersecurity precautions. Please make sure you take that. Park in a lighted area if it is dark.
You mean
all that stuff.
Not the cybersecurity precautions for parking. You mean the security?
I'm just saying, just be safe and have a great holiday season. Of course, we'll see you. But just wanted to share that and have a great cricket season for the next 6 months. A lot of cricket coming. I hope India will do well in one of those.
Well, thank you all again. See you next week.